Solicitor.
Thank you, Mr. Chairman. Not the first item on our report, in fact, the only item on our report, is consideration of a declaration of municipal curative amendment. This, as the board knows, I believe, and we have talked about this before certainly, the current state of the law in the Commonwealth of Pennsylvania, as referenced by two common pleas court decisions in the Philadelphia area, is that the use of property as a convenience store and gas station as a combined use is a use that is required to be provided for by law, and that use would be contained in the zoning ordinance. However, the Joint Municipal Zoning Ordinance does not have such a use. We are in the process of drafting an ordinance that will ultimately, after review by the Jointure municipalities, hopefully be adopted and serve as that ordinance. But in the meantime, there is a procedure set forth in the municipalities planning code that allows municipalities to examine their own zoning ordinances from time to time, and if they determine that there may be an invalidity or something unconstitutional in the zoning ordinance, it gives them the opportunity to declare that invalidity, to announce that they are going to cure the invalidity, and then provides a time period for the drafting and ultimate enactment of an ordinance to cure the invalidity. And during the time between declaration of invalidity and enactment of the ordinance, no application can be filed that would seek to avail itself of the use or provisions of the zoning ordinance that have been declared to be invalid. With this gas station convenience store use, we have consulted with the Jointure municipalities, being Wrightstown Township and Upper Makefield Township, all three of the solicitors, and so far those two boards have agreed that it would be wise to cut off any additional filings or challenges to the validity of our zoning ordinance with regard to this use. And the first step to doing that is to adopt a declaration that we have drafted, and I'll read the declaration: invoking procedure for Joint Municipal Curative Amendment. It says, pursuant to sections 812-A and 609.2 of the Pennsylvania Municipalities Planning Code, the Board of Supervisors of Newtown Township hereby declares that the Joint Municipal Zoning Ordinance or portions thereof may be substantively invalid. The Board of Supervisors further proposes to prepare a curative amendment to overcome any such invalidity. It hereby invokes the protections of sections 812-A and 609.2 of the Pennsylvania Municipalities Planning Code in order to consider and, if appropriate, adopt a curative amendment to its zoning ordinance to correct any substantive defect in its zoning ordinance, and that is resolved and enacted by the Board of Supervisors of Newtown Township this 11th day of December 2019. If the board is of a mind, it would be a motion to adopt that declaration resolution.
Do I have such a motion?
So moved.
Do I have a second?
Second.
I have a motion and a second. Now this was also recently passed by the Jointure, I believe, the other night.
That's correct.
We had a Jointure meeting. So now, can you just go into how this protects the township in regards to the gas station, convenience store, proposed property use?
Right, so if this is from the date of this declaration, and to follow up on who's done it so far, Newtown is last Monday, it was Wrightstown. Last Wednesday, it was Upper Makefield, and last Thursday it was the Jointure meeting as a whole. Newtown is now the last township considering this. From this date, for a period of 9 months, and there's a typical period of 6 months for an individual municipality, because we're in a jointure of 2 or 3 municipalities. We have 3. we have 9 months to enact an ordinance. For that 9-month period, nobody can come in and file an application seeking any kind of land development that deals with the gas station convenience store use, nor can they file a challenge to the validity of the ordinance, again, between tonight and a date 9 months from tonight.
And without this going into effect within the jointure, the township itself would have been subject to someone coming in and doing this, correct?
That is correct.
So this is protecting us and also establishing possible locations within the jointure so that the township isn't the only location that this particular use can be done in.
It's exactly correct.
Okay.
I have a question. You said 9 months. 8 months was in my head from somewhere. Was it?
It was 6, and I believe you and I actually exchanged emails. When I said 9 months originally, you said, well, I've looked in the MPC and it says 6 months. And I said,
Okay,
we have to look at it's 9 months.
It's 9 months.
It's 9 months.
But to be clear, this does not protect us from Provco representing Wawa that already submitted an application for this use in the commercial research district. Is that
The OR district, correct.
the OR district?
Correct.
So
that is a substantive challenge that was filed before this declaration of
This,
invalidity.
as far as building it on the bypass, closing the barn door while the cow's already out, it's not going to protect us against.
It's not going to protect us against that challenge. Of course, if that challenge is denied, if that challenge does not succeed ultimately, then they're shut out. And they're subject to this, they're subject to this.
I'm not sure how this all works, but I recall the attorney, Mr. Van Leuvenay, saying that he would bring Newtown to court because we do not have a particular use for that. And I'm not sure how that fits in with this application that they resubmitted, but could they still bring us to court if we, even if we did have a change in the zoning somewhere that allowed it, hopefully not on the bypass, they could still bring us to court to try to get that location that they're looking at?
Well, bringing it to court is skipping a step. They have filed what's called a challenge to the substantive validity of the ordinance. That's already been filed. It's already pending before the zoning hearing board, who will hear that application. It's not a land development application.
Okay,
Let me finish. To challenge to the validity of the zoning ordinance. If the zoning hearing board grants that, then it's up to the parties in opposition, namely, possibly, I don't think we've gone there yet, but the township, can take an appeal to that. And that's the way it would end up in court. If the zoning hearing board denies the challenge, Mr. Van Leuvenay's client may want to go to court and challenge that denial. So that's the way it's going to get to court. Mr. Van Leuvenay can't take us directly to court because we don't provide for this use. There's a procedure to do that, and they have availed themselves of that procedure prior to this declaration of invalidity. This is protecting us from any other challenges for the next 9 months.
So the next step with regard to the Wawa on the bypass is the zoning hearing board?
Correct.
Okay, thank you.
I have a question. Sorry to beat the dead horse here. So if we change the zoning within this 9 months to properly account for this new use, how does that affect that current?
It doesn't unless they agree to withdraw their challenge and submit plans to develop a property subject to that zoning.
Right.
They'll have a choice. And if they don't like the new ordinance, they can proceed with their substantive validity challenge.
Okay, thank you.
Any other questions? From the public? Seeing none, I'll call the question. All those in favor?
Aye.
Any opposed? Passes 5-0.